Wait, number 8? No, not you. You don't see it. But Freya, you know, you respond.
Mr. Bruce, are you on the line?
Yes.
Okay, Mr. Bruce, just wanted to give you a heads up. We're calling another case before these Matador cases, okay?
Thank you.
All right. My name is Gregory Chikalian. It's 8:27 a.m. on the 16th, the 18th of June. This is our regularly scheduled status conference docket. We're going to start with a case that is actually listed as number 8. It's 26136, Coterra Energy. Entries of appearance, please.
I'll go ahead and go first, Mr. Hearing Officer, just to make sure you can hear me. This is Matt Beck, Pfeiffer, Hansen, Mullins, and Baker on behalf of Amtex Energy, Inc. and Mark Trebe.
Thank you, Mr. Beck. Mr. Holliday, there you go.
Hey, there we go. Sorry, guys, had my computer on mute. Good morning, everyone. Ben Holiday on behalf of the applicant.
Okay, perfect. I got a motion yesterday, and the reason we have these status conferences is so that I can understand the issues going forward, so that I can schedule these things properly. I know the parties are asking for an August 12 contested hearing. So let me start with you, Mr. Beck. What are the issues that you have with this application?
The proposed well enters into the Pearl, excuse me, let me find the exact name of the East Pearl Prospect area, which is subject to a joint operating agreement, which Coterra is a member of that joint operating agreement. Coterra did not comply with the procedures to propose to drill a well under the joint operating agreement. The wells are not, they will strand acreage of the joint operating interest owners for the prospect unit. And Amtex has permits for that unit and is proposing, I think, should be sending out either today or tomorrow AFEs for competing wells that will compete with this chili fed proposal in the application. I think those are the issues so far.
Okay, it sounded to me like there was a mix of issues in there that, Mr. Beck, I think you would recognize that we don't have jurisdiction over some of those contract issues, right?
Yeah, I recognize that you wouldn't have jurisdiction over, for example, what would be obviously a breach of contract provision. I know that the division does take into consideration when looking at competing applications, the parties' negotiations. I think it would probably fall under that, but yes, I understand, Mr. Hearing Officer.
Okay. Now, I also thought I understood that you that your client is sending out proposals. You said AFEs, but did you mean proposals?
AFEs and yes, and drilling proposals under the East Pearl prospect to the joint interest owners, proposals to drill. Yeah,
To compete with Mr. Holliday's client's proposal.
exactly. Yes.
Okay. When do you plan on filing that application with the division?
I expect it will be shortly after the proposals and AFEs go out. So if they go out this week, that will be sometime next week. We're shutting down today at noon to move offices, so I'm going to be without a computer or anything for a few days. But if they go out today, I expect they'll be filed next week.
All right, thank you. Mr. Holliday?
Yeah, I really don't have anything to add. We would like to drill the Chile FedCom through no fault of Mr. Beck's. I mean, we've been going back and forth. That's the first I've heard of the nature of the objections, but I think I know that Coterra has an interest in moving this along and expediting it. And that's why we would like the August 12th date. And we think that gives everyone enough time to send out proposals and to develop our arguments for hearing.
Okay. Mr. Holliday, how many witnesses do you anticipate?
We would have, I would likely 3, I would say. We'd have the land geology. And I haven't clarified with Coterra, but likely we would have an engineering witness as well.
Okay. And Mr. Beck, same question?
Probably the same answer, Mr. Hearing Officer. I expect we'd have the same witnesses.
So Mr. Beck, you're representing 2 different entities, is that right?
And it depends how you classify them. Amtex is an entity, and Mr. Trebe is an interest owner in the acreage. An
Right.
individual.
So would you explain to me how that works when at some point Mr. Trebe's interests may diverge from Amtex?
Yeah, certainly I think that's something that everyone contemplates, which is something we have to recognize on the front end if we're going to represent multiple parties in a proceeding. That's been addressed at this point. That's why I represent both of them. If something comes up where I'm prohibited to do that, we've got in place procedures that address that issue. But for right now, they're both objecting to and opposed to Coterra's proposed application and proposed well, which is why I'm representing both of them.
It sounds like it's Amtex that is going to file a competing application. Is that right?
Yes.
And what you're saying is Mr. Trebe is in line at this time with Amtex's proposal?
Yes.
Okay. All right. Do you anticipate Mr. Trebe testifying?
I don't. He might testify, and we obviously would address that in our pre-hearing statement. I don't know that he's going to have much to offer other than his opposition, but I will speak with him about that. And if he's going to testify, as I said, it will be just as a layperson, an interest owner who's objecting to the application.
As an interest owner, is there a JOA between Mr. Trebe and Amtex?
Yeah, Mr. Trebe is one of the parties to that JOA, the East Pearl Prospect JOA that Coterra is also a party to.
All right. Okay. Mr. Holliday, anything further?
No, sir. Thank you.
So Freya, would you issue a pre-hearing order for the August 12 docket?
Yes.
We'll get that out probably by tomorrow to the parties. Anything further, Mr. Beck?
No, I just wanted to say thank you for accommodating Mr. Holliday and us, and sorry for everyone else who got pushed back a few minutes, but I appreciate it, and I appreciate Freya reaching out yesterday to confirm.
By all means. Thank you very much. All right, we're off the record in 26136. Let's move on now to Matador Production. There are 3 cases, 26000, 001, and 002. Entries, please.
Mr. Examiner, Jim Bruce representing Matador. I will get a formal entry of appearance in later.
Mr. Bruce, will there be a substitution of counsel form?
Yes.
All right.
And good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of COG Operating and Mongoose Minerals.
Thank you. And you've objected?
We have objected.
What's the purpose of the objection?
We are planning to file competing applications that will be set initially on the August docket.
Okay,
So proposals have gone out and we would file for August.
okay. In other words, meaning that you'll file your application in early July for the early August docket. Okay.
Correct.
Do the parties want to set a contested hearing at this point?
We would request a contested hearing, and if possible, we'd like the August 25th docket.
Mr. Bruce?
I don't think I have any objection. I was originally going to ask for a July, another status conference, but it sounds like that's useless. So August 25 would be fine.
All right, we'll issue a pre-hearing order for August 25. And I don't think it's useless, Mr. Bruce. If you want to continue your cases to the July status conference docket, you're more than welcome to.
Thank you.
And then, Ms. Hardy, when you do file, I'm sorry, Mr. Bruce?
And I believe that case 002 is going to be dismissed.
Okay. So you're going to dismiss that case?
Correct.
Okay, when are we going to see that dismissal notice?
Let's ask for Monday because my
Sure.
computer is getting a little cranky today.
All right, very good. So Ms. Hardy, back to you for a moment. When you file your competing applications, first of all, does that dismissal change anything for you?
I'll have to confirm with my client, but because I'm not sure exactly which acreage that impacts.
Mr. Bruce, can you give us a little bit more on what the application in 26002 requests and why you're dismissing it?
I can't tell you why we're dismissing it. I believe it's a Wolf Camp case and the other two are Bone Spring.
Ms. Hardy, does that help you at all?
I don't think it changes our need for a contested hearing
I
on the
wasn't
bones,
sure.
on the Bone Spring, right?
Let me look up the case. Hold on one second. Let me see what it says in the description for 26002. Maybe this will be helpful. It says here, application of MRC Hat Mesa LLC for compulsory pooling, Lee County. Applicant in the above case seeks an order pooling the uncommitted interest owners in a standard 320 acre, more or less, horizontal well spacing unit in the Bone Spring formation. You said Wolf Camp, right, Mr. Bruce?
Yeah,
This one is Bone Spring, so maybe it's another case that you want to dismiss, or are you sure about this case number?
well, I'm sure about the case number.
All right, I'll finish reading what it says here in the description. In the Bone Spring Formation, underlying the east half of section 9, and then there's the rest of the legal description. Applicant seeks to initially dedicate the above referenced spacing unit to the proposed state com well to be drilled from a surface location, blah, blah, blah. I'm not going to go through all that. Also to be considered will be the cost of drilling, completing the well, allocation of costs, actual operating, designating Matador as operator, and then we have our typical.
Right.
Yeah. So what?
I'm kind of operating in the dark here, Mr. Examiner. So
I see. But you are sure about that case number that you're going to dismiss it?
yeah, it's the last case of 3.
I didn't hear you.
That is the last case of the three.
Numerically, it is, yes. 26001 deals with the same, deals with the bone spring in the east half of the east half. So it's another bone spring case, 001. And then the one ending in 0, let's see that description. That one is the west half of the east half in the bone spring. So there are 3 bone spring cases. So I guess from those descriptions, I don't have any idea.
Well, I guess if Matador is seeking to drill 2 stacked 40-acre units, it doesn't need the entire east half.
Okay. Okay. Okay, very good. All right, Mr. Bruce, we're going to issue a pre-hearing order for August 25th. Is there anything else?
Not for me, sir.
Ms. Hardy?
No, thank you.
All right, thank you. And Mr. Bruce, if you want to continue your 3 or your 2 cases to the July,
Let me ask my client that after the hearing.
yeah, it's totally up to you, but if you want to, there's nothing stopping you from doing that. It may be productive.
Okay,
Well, thank you. Feel better.
that would be July.
Freya, July what?
23.
July 23, Mr. Bruce.
Okay, thank you.
You're welcome. We're off the record in those 3 cases. Let's go to American Energy. This is 26060, American Energy. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Permian Operating Resources, or Permian Resources Operating, sorry.
And have you objected?
We have entered an appearance and objected.
For what reason?
One, the application, we disagree with it, having to reopen these cases. We believe that that Permian met the burden required, the notice burden required under the rules and has satisfied the division's pooling requirements. And that's why orders were previously entered in all of these cases, including the 2 that are still before the division that the hearing examiner included in the order.
Okay. Mr. Samanyengo, are you with us? Freya, do we have Mr. Samanyengo?
I'm not seeing him.
Freya, if he's not here, we're going to dismiss these 2 cases as failure to prosecute. Was he given notice of today's docket?
He is on our distribution list. It's possible he is under the assumption that the hearings start at 9. We have provided several notices, though, of the new start time.
I'll recall this case after 9 o'clock, just in case he's under that assumption. But if he's not here, Freya, we're going to dismiss this case for lack of prosecution. It'll be a dismissal without prejudice, but it will be a dismissal. So we're going to recall this case. Thank you, Ms. Vance. We're off the record.
Thank you.
Let's move on to Parish Operating. This is 3 cases together, 26123, 2425. Entries, please.
Mr. Examiner, Jim Bruce representing Red River.
Red River, how does that relationship to Parish?
Parrish is its operator of record.
I see. Okay. So Red River. All right. Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of EOG Resources, and we have entered an appearance and objected.
For what reason?
In this case, I believe the parties are negotiating And that's the extent of what I understand at this point.
So you're just looking for more time to negotiate.
Correct.
All right. No competing applications at this point.
No, not to my knowledge. And I believe that my colleague, Mr. Rankin, may have spoken or emailed with Mr. Bruce yesterday. We would like to, I'm not sure what Mr. Bruce would like to do, but if there is going to be a contested hearing, we'd like to push as far out as possible
Okay.
and allow the parties more time to negotiate.
Mr. Bruce?
Yeah, we're amenable to that, Mr. Examiner. I mean, I
That's not-
looked at Priya's emails, and August 25th is the latest one, but if September would work better for Paula, that's fine.
Mr. Bruce, I'm looking for more information about what's going on between the parties. You said that there were some emails between you and Mr. Rankin. What's going on?
Yeah. The parties would like more. This is a kind of a messed up well unit, and lots of little title in there, lots of nooks and crannies, and they would like additional time to negotiate.
Well, you filed applications for a hearing, right, Mr. Bruce?
Correct.
Okay. And were the parties negotiating when you filed the application?
Yes, they were, but they've intensified since then.
Okay. Well, I'll give this another status conference in July to see where we are. And if
Okay.
I'm sorry?
Thank you.
So you'll move this to the July 23rd, I think Freya said earlier, docket. But if the parties haven't come to an agreement by July 23rd, then we'll set this for a hearing.
Okay.
All right, July 23rd, that'll be the final status conference. I'm just letting you know, Mr. Bruce.
Thank you.
All right. Ms. Vance, anything further?
No, thank you.
Mr. Bruce, anything further?
No.
Now we go on to Avant Operating. These are the last two cases on our docket, 26137, 26138.
Good morning, Mr. Hearing Examiner Caitlin Luck, appearing for Avant.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of EOG Resources, and we've entered an appearance and objected.
For what reason?
Again, it sounds like there's some negotiations between the parties. I think there might be some existing spacing units, and there's some conversation around some coordination related to the existing wells and spacing units where Avant has proposed their wells.
Okay, Ms. Luck?
And that's correct. I know EOG has some concerns with the placement of the wells, and we're trying to work through that. However, Avant, on behalf of Avant, I reached out to EOG before this hearing and talked about a contested hearing, and I think we're all in agreement about an August 18th date.
Okay, which date? August 18?
Yes, sir.
All right, we'll issue a pre-hearing order for August 18. If EOG decides it wants to file competing applications, I would suggest that it does so that they, sometime in early July, so it can get on the August docket.
Understood. Thank you.
All right.
And we're in agreement with the August 18th contested hearing date.
Based on what Ms. Luck said, I understood that. Thank you. All right, anything else, Ms. Luck?
No, thank you for your time.
All right, thank you. We're off the record in these two cases, and we're basically done for Miss Hatley. Did you have something? Okay. Did you enter an appearance in any case? I understand perfectly. Okay. And she does so well. Miss Hardy, Miss Hatley, if you want to leave, feel free. I'm going to stay around till 9 o'clock. Miss Vance, I'm asking you to stay till 9 o'clock. It's 10 minutes.
No, those are billable hours.
I'm sorry, Miss Vance. You'll have to just grit and bear it. So Freya, we're going to be off the record for the next 10 minutes, and then we'll wait for 9 o'clock and go back on the record.
Okay.
Thank you. All right, we're back on the record. It's 9:01. No, it's 9:02. We're back on the record to recall case number 26060. This is American Energy's case. Entries of appearance, please.
Jonathan Samaniego, Representative, American Energy.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Permian Resources Operating. And we have entered an appearance and objected to this case.
All right, thank you. And the purpose of the objection?
Permian has met their burden under the division's rules for notice, and that's why orders were entered. Yeah, we believe that this case should be dismissed.
Right. And I did grant the dismissal as of 4 cases, but I did not grant the dismissal as of 2 cases. Those 2 cases, I saw evidence of an interest and I saw evidence that the notice may have been faulty. So, Mr. Samaniego, can you tell me why you were not present at 8:30 when we started our docket?
I'm having technical difficulties this morning.
Oh, so you did know that we started at 8:30?
I did not, but even getting on before 9, I'm having great difficulty even with the portal.
Okay. In the future, Mr. Samaniego, we're starting at 8:30. That was in several of the notices that were sent to you, that we're not starting at 9 anymore.
Yes, sir. I apologize for that. Yes, sir.
Okay. No, that's why I waited until 9:02 to call this case again. Okay, Mr. Samaniego, we need to have a hearing to determine whether notice was proper or not. So, Freya, when is the next possible hearing date?
We have a special docket on July 7th. We have, I think, 3 other contested hearings set that date. But that would be the next one unless you wanted to do June 30th, but that's not enough time, I don't think.
Okay, all right. Mr. Samaniego, this is your case, so I tend to give preference to the applicant. When will you be ready for a contested hearing?
At the earliest.
Okay, let me ask Ms. Vance. Ms. Vance.
We're
when will you
ready. Oh, I'm sorry.
I was just gonna say, when will you be ready?
We're ready right now.
You are ready, okay.
We're ready right now to move forward. We have our witnesses available. We would like to move forward to discuss these issues. And don't really believe that a contested hearing is necessary, especially based off of the application that was filed that doesn't have any requested relief listed in it, which makes the application itself faulty. Even on that basis alone, it should be dismissed. But we are prepared to address the 3 issues that the hearing examiner outlined in the order that was issued.
Okay. Mr. Samaniego, when it sounds like Ms. Vance is ready. Are you saying today, now?
We're ready right now.
You are ready now. You have your witnesses available.
We have our witnesses available.
All right. Mr. Samaniego, are you ready to proceed?
I'll go ahead and I'll take I'll go ahead and prepare for what was it, the 7th?
Well, the options were June 30th or July 7th.
Okay, I'll take the July 7th.
Okay,
But-
Freya,
but-
hold on, Mr.
But
Samaniego.
I also want to make note on there.
Okay, Mr.
that way
Samaniego,
we're-
hold on. I'll give you an opportunity to speak, but let me finish. Freya, you said that we have 3 other contested hearings on the July 7 docket.
Yes, I'm pulling up the docket just.
All
to
right,
be
hold on,
sure.
Mr. Samaniego. We're going to check the docket. Will you check June 30th as well? I'm curious to know. Oh, is that the special docket with a lot of cases on it? Okay.
Yes, special docket, and we have 1 contested hearing.
Oh, we do.
I may have been wrong, misspoken about July 7th. I'm showing. Oh, no. I'm just having a hard time pulling up my spreadsheet.
Take your time. I'm not rushing you.
Okay, yeah, I was incorrect. There's one remaining contested hearing on July 7th. It's the MRC Avant contested hearing.
Ms. Vance, are you involved in?
That's the one we were discussing during the break for the July 7th, so I will be here. Actually, that one, I'm not going to be here. I'll be in Belize, sorry, scratch that. But my colleague, Mr. Rankin, would be available, as well as Mr. Feldewart. He's going to be making a guest appearance this summer.
Oh, good.
And I do want to,
Hold on, Ms. Vance.
I know, I just want to put a point, Pen, and there is something I do want to
Fine.
ask on the record, if possible, before we go
Yes,
off the record.
Fine, we'll address your question in just a moment.
Thank
So,
you.
Mr. Samaniego, it looks like July 7 will work for the division. Does it work for you?
No, because I object to Mr. Rankin. He's already had bad intentions since the beginning, even worse than Mrs. Vance's behavior. So that's why I'm going to say that I think we should wait until Mrs. Vance gets back from Bolivia. That way we can then continue, since she's familiar with her own responses in the case.
Okay, I understand. No, thank you. I understand your objection, Mr. Samaniego, but it's up to the division to set this case. If you want to file a motion, it's trying to disqualify Mr. Rankin from representing Permian, you're more than welcome to, and I'll consider it. But at this point, you wanted the soonest date possible. You didn't go for June 30. I'm not sure why, but that's okay. July 7 is open, and that's the time that we're going to set this contested hearing. Now, I want to ask you a question, Mr. Samaniego. How many witnesses will you have?
Right now, they're still to be determined at this time.
So, Mr. Samaniego, I want to be very clear. I want to be very clear at this junction with you as a pro se litigant. I'm not giving you legal advice, but I am going to let you know how this works. Any witness that testifies must be sworn in and testifies under oath. Do you understand?
Yes, sir.
Okay. Any document that you submit, you have to provide some foundation for that document. In other words, if you submit a deed, let's say it's a deed to show that you have an interest in something, then you need to provide foundation so that the tribunal can give it the weight that it determines it is applicable.
Okay, but I'm fine with that. If you want me to show chain of title on every one of my deeds, that's fine. I'll go through the burden of doing that. But at the same time, that it's only appropriate to make sure that Permian does the same. And I've already presented 2 documents as attachments B and C showing that they have wellbores. They don't own no physical interest to be developing these lands.
So Mr. Samaniego, I want you to be clear about what the purpose of the hearing is. Okay, Permian is not accused of wrongdoing in this hearing. Now there may be evidence of that, and I'm not saying that there is or isn't. That's outside the scope of this hearing. Let me explain what your application, because Ms. Vance basically objected to your application, okay? And I'm not going to sustain that objection because I'm giving you as much leeway as I possibly can as a pro se litigant. Now, your application seeks to reopen the compulsory pooling orders based on lack of notice. That's what we're going to be hearing on July 7. We're only going to be talking about notice. The idea that there is an interest in these 2 cases is something that will be tangential, but will also be valid as an issue. But I want to make sure.
If I may just,
Mr. Samaniego, please don't interrupt me. I'm trying to give you as much leeway as I can, but you really don't want to interrupt me again. So, Mr. Samaniego, the issue, it matters what issue is relevant for the hearing. We're not going to go down some rabbit hole of the idea that Permian is doing wrong by their well borers. That's not the purpose of this hearing. It's a very specific purpose because the rule, and I have the rule here in front of me. Let me read you the rule. Give me a minute. And I have to find that part of the rule because you didn't cite.
If I may, while you look for it, just please, my claim is not Permian's doing wrong. They got well bores. They can't be doing this. I get it. Okay. My claim is that they don't have an interest, therefore they can't object to my hearings. Because
Okay.
I've proven that they don't have an interest, therefore they don't have a right to whatever they're doing, okay, but they don't have a right to participate in my hearing that I'm moving forward with because they
Okay.
don't have an interest.
Okay, I understand, Mr. Semenienko, and I'm looking for the part of the rule that you have filed these applications under because the applications themselves are a bit of a mess. They asked for the commission to take up these cases, but they're not properly before the commission for various reasons. So I was trying to give you as much leeway as possible, and I accepted them into the division's hearing docket. And give me a minute, I'm still looking for the rule, unless you know it, Ms. Vance.
I think you're looking for, give me 1 second.
Thank
I
you.
have it outlined in my notes.
Perfect, thank you.
One thing I do want to ask, and down the line that you were just speaking of, regarding the applications is, we understand that that we're going to discuss a limited scope on the contested hearing, which, by the way, we are more than willing to be here for the June 30th because I can be available on that date.
Okay,
And if Mr. Semenienko would like me to be the person who
okay,
is representing Permian, I can be available on that
Okay.
date, and I'm
Okay.
happy to do that. But on the point of his application, one of the things is the requested relief. Permian would very much like to know on the record what the point is. What does Mr. Semenienko want
okay. Well, I'll ask
by
him.
reopening these cases?
I'll ask him in just a moment, but I'm still looking for this rule. Do you say
Yeah.
you found the rule, Ms.
Yeah.
Vance?
Give me 1 second. It's actually in an email that I sent yesterday. I believe, are you looking for the notice requirements for specific adjudication?
I'm looking for the rule that allows a party like Mr. Semenienko, who owns an interest, who claims that he was not given proper notice to reopen the compulsory pooling order. It's here somewhere in the rule and I can't find it.
Oh, the adverse party affected.
That's the one.
Yeah. Give me a second.
I would have thought it was the end of the rule, but I can't find it yet.
Is it under 1915-49 in MSAC?
Let me look, Mr. Semenienko. Maybe it is. I don't know. I don't think so, Mr. Semenienko. That doesn't look.
But that statute is grounds for reopening the case based on alleged failure, correct?
I believe the rule says that it is, and I'm trying to find that part of the rule. So since you didn't cite it in your application, you're forcing me to look for it, which I'm doing now. So hold on a minute.
Are you talking about rehearings 1915-425?
I looked at that. I didn't see what I was looking for there, but let me keep looking. That's about the commission, though. It's all about the commission, and this is not the commission. This has to do with reopening an order.
$1915-412D.
No wonder. I'm in the completely wrong area of the rule. Thank you.
I got some help from people in the background.
Oh, well, thank you for whoever's helping. Mr. Semeniengo, under 1915-4-12, D as in David, it says evidence of a failure to provide notice requires, another part of the rule requires, may upon proper showing be considered cause for reopening the case. That's the part of the rule that we're going to be operating under for the contested hearing. Mr. Semeniengo, in your applications seeking the commission's jurisdiction, which your applications don't qualify for because they're not within 30 days of the compulsory pooling orders that were issued to Permian, you alleged that there was a failure to provide notice under the rule. When I dismissed some of your cases, but not two of them, I thought that there was a genuine issue of material fact in two of the cases, which is why we're going to a hearing. Now, this is the part of the rule that we'll be dealing with. Do you see that?
I'm gonna have to study it more.
That's fine. That's fine. But I'm giving you the part of the rule that we're operating under. Did you write it down?
Yes, sir. 1915-412D.
That's right. There you go. So the issue is whether Permian failed to provide you notice in two of the cases. That's the issue. That's the only issue that we are dealing with at the hearing. Now, Ms. Vance also said that she's available June 30th. Would you prefer June 30th?
And again, I'm available right now, and we very much would like to proceed.
I have to give.
And also, if I may, because Vance she made her statement in the beginning. I want to come out and say that by Mrs. Vance's own statements, that American didn't have an interest, so they weren't allowed a right to get notice. So by her own words, Permian didn't provide notice to American, and that was under all four of those dismissed cases.
Okay, but Mr. Semeniengo, would you please answer the question I asked you?
It's like a timing issue. I got other hearings, and that was my reason for pushing it off to July 7th.
Okay, Mr. Semeniengo, I accept your what you say as true. So we will set this for July 7, but Ms. Vance will not be the counsel for Permian. It'll be Mr. Rankin. So I just wanted to make sure you understand that.
Yeah, and don't take my word for it. Talk to Jesse Tremaine. He's aware of all the shenanigans that's been going on. He's aware of the hearings that I got coming up.
So, Mr. Semeniengo, we're going to issue a pre-hearing order for July 7. We're on a trailing docket, which means there's another case in front of yours. So I don't know what time we're going to start. It may be 8:30 if the other case goes away. So you need to be prepared to start at 8:30 with your witnesses.
Yes, sir. And I greatly apologize for that. I'm sorry.
Now, Mr. Semeniengo, Ms. Vance asked a valid question earlier that I'm going to pose to you. If you do succeed at the hearing to show that notice was not proper, what do you want the division to do if we reopen the compulsory pooling orders?
To start off with, I like Americans' just right to participate and to collect his fair share of proceeds. And I want to kind of leave my right and hold that open because there could be other demands as we proceed on. Like, for instance, waiving the penalty fees. That'll be also a second thing that I'm requesting. And as I requested in my filings, I mean, if you look down on the preliminary statement on the conclusion, Ms. Vance said that I didn't have a remedy, and that's far from the truth. If you look on it, I'm asking for a stay or a dismissal of the cases because they didn't provide notice, which is following New Mexico law, which those two are just remedies under New Mexico law as automatic. And then also on here, I'm saying to recognize American interest in the proposed units, waiving any penalties on participation costs, et cetera. And again, Mrs. Vance is doing it again as a compulsiveness. The fact that she's saying I got no remedy, and herely on my conclusions, I'm asking for those as my remedies.
Okay.
Another
all right,
remedy. Another remedy. I want all licensed attorneys under rule. I want to get it on the record. Under Rule 16-8038 NMRA, Rules of Professional Conduct.
I'm going to object to this because this is personal attacks on me and my colleagues, and it is totally inappropriate.
Mr. Samaniego, could we just dispense now with the citing of the rules of ethics just for now? I understand that you have issues with the attorneys for Permian. I'm not going to deal with that now. I'm just trying to set a contested hearing. We have a date.
Can we agree that American's remedy is clearly on its filings?
Mr. Samaniego, that's not an issue.
Actions were
Mr. Samaniego, just control yourself for a minute. You're talking over me, and the transcript won't be able to pick up our words. Mr. Samaniego, I'm not worried right now about the remedy. Ms. Vance asked a valid question, and that's why I asked you to address it. You have addressed it. Let's not go on about that for now. First, let's see what your evidence shows. So please follow all the rules that are laid out in the pre-hearing order that you're going to get tomorrow. Do you understand?
Yes, sir.
All right, perfect. So we will set this for a July 7 contested hearing, which may start at 8:30. I'm just repeating myself now because I want to make sure you understand. So you'll want to get on early and make sure you don't have technical difficulties, because if you're not there, that's not going to work out for you. Your witnesses will need to appear visually. I can't swear someone in if I can't see them. So I'm letting you know now that if you have a witness, including yourself, you need to be able to turn on your camera so that I can see you. Do you understand?
Yes, sir.
Okay, good. You're also welcome to appear here in person if you want to.
Yes, sir.
Okay. Ms. Vance, did you have something else?
I just, for the record, would like to say that these, obviously we'll go to this contested hearing on the issues outlined in your order, but I do want for the record to be clear that in the case 24837, which was the original case number for that was 22554. That order in that case, which does have him listed as a notice party, that order was issued on January 31st, 2022, and no de novo application was filed within the required time frame. And in case 25137, again, Mr. Samaniego was noticed properly, and that order was issued on April 1st, 2025. No de novo application was filed. And Permian finds it very improper that we are here reopening these cases when they have orders that have been issued ages ago, and they are moving forward with these developments. And in fact, in the Water Buffalo, the 24837 and the original case 22554, those wells have been drilled and they have been producing.
And Mr. Samiengo, I suspect is getting his due money.
He is a pooled party.
Right.
Under that. He is a non-consenting pooled party at this point.
I understand. And we'll see what the evidence shows. And you'll have an opportunity to show the division that Mr. Samiengo was noticed properly. Mr. Samiengo will have an opportunity to show that he wasn't noticed properly. Mr. Samiengo, I want you to understand one other thing about the hearing, which you may or may not understand. You have the burden of persuasion.
Mhm.
Do you know what that means?
If you could explain it to me.
Yeah, be happy to. I'm not giving you legal advice, but you can look this up, and I recommend that you look it up. Burden of persuasion means you filed an application for the division to reopen its compulsory pooling orders based on failure of proper notice. Now, it's your burden to show that you did not receive proper notice. So you're going to be going first. Okay, you're the applicant. You're going to be going first. You're going to be putting on your case in chief. When you're done with your case in chief, then Permian has a case in chief. They will be able to show that your evidence is either not correct or that they have other evidence that outweighs your evidence. And then you will have an opportunity to cross-examine their witnesses, and they will have an opportunity to cross-examine your witnesses. Do you understand?
Yes, sir.
Okay, good. Then I don't think anything else. Yes, Ms. Vance.
Just one other thing. I'm glad that you outlined that because
Sure.
I did want to discuss procedurally how
Okay.
this will move forward. The other thing I just want to be clear about that we are discussing the notice. And to your point earlier, maybe some piece of that will be related to whether or not Mr. Samaniego has an interest. But I just want to be clear, we're not going to be going to this contested hearing to discuss what that interest is, because this is not the forum. The division does not have jurisdiction over title. And if Mr. Samaniego would like to litigate title, there's a different forum for that.
So, Mr. Samaniego, let me translate what Ms. Vance just said. As I quoted to you from the rule, someone who did not receive proper notice under the rules has a right to come back to the division and reopen the compulsory pooling orders. And that's what we're doing on July 7. Now, interest, to receive proper notice, you have to be an interest owner, okay? And then there's other, give me a minute here. 1915-49. So the notice requirements are under 1915-49 and 1915-412 A1. I'm not giving you legal advice by citing to those rules. I'm letting you know that's where those parts of the rule lay out what is proper notice. I highly recommend that you read them very carefully so that you know how to present your case to the division. Do you understand?
Yes, sir.
Okay.
And also, if I may, because there's a lot of obstacles American has got in front of it now. But I want to put the same burden on Permian, not to prove that they have interest to develop, but to prove that they have interest beyond those wellbores to validate objecting to my hearing in my case. Because if
So
they
Mr.
don't have valid, if they
I'm
don't have
sorry,
valid
so Mr.
interest,
Samaniego, I've trying to be very clear with you. They don't have a burden in this case of persuasion. You have a burden to persuade the division that you did not receive proper notice of the compulsory pooling applications. That's your burden to persuade us. They do not have a burden to persuade us that they have an interest to be objecting. I want to make sure you understand.
An objecting party cannot object unless they have a valid interest.
Okay, so Mr. Samaniego, we're not going to get into a legal argument here and now. If you want to file a motion, I don't see how that helps your case. I've been very clear with you what rule we're operating under and what you need to do going forward without giving you legal advice. I don't think we're going to get any further today, so we're going to go off the record in this case, and we will issue a pre-hearing order. If there is a motion, then I will hear the motion, but obviously we don't have a lot of time to file motions and get responses before July 7.
Okay, and to satisfy the examiner, how far back in chain of title are you requesting that I go? I mean,
Well,
since
I'm
I'm
not.
the only one who's going to do it.
So, Mr. Samaniego, I'm not, that's legal advice and I can't give you legal advice. What I can tell you is that if you read the notice parts of 1915-4, which I've cited on the record, you will see what you need to show the division regarding proper notice. So, if there's nothing else, then we're going to be off the record, and we'll see you on July 7 at 8:30, Mr. Samaniego. Thank you.
Thank you.
Thank you, Ms. Vance. We're off the record.
Thank you.